We're back now to answer your legal questions, and joining me this week is LaKosha Roberts with the Southwest Louisiana Law Center. Thanks for coming in today.
Thank you for having me, Ms.
All right, let's get to our first question of the day. I have heard of mediation and arbitration, and they seem to be the same or similar. Are they the same? And if they aren't the same, what are the differences?
Well, Ms. Agnes, arbitration and mediation are different terms. Even though a lot of times you hear them used synonymously, they are different. And there are distinct differences that I think the viewer will need to understand in order to understand the distinct differences. Now, although both of them involve neutral third parties who oversee those processes, the neutral third party tries to help participants in finding common grounds during a dispute. The mediator facilitates the communication so that the parties can reach a resolution that works for both of them, generally speaking. An arbitrator, on the other hand, serves as a judge who is responsible for resolving the dispute. A mediation allows parties to reach a collaborative settlement, but could actually end in an impasse. But with an arbitration, it can wrap up conclusively, and it does not allow the disputants much authority in rendering a decision.
All right, now let's get to our next question. I need to file a lawsuit, but I do not have a lot of money to hire a lawyer and to actually file it. What, if anything, can I do?
Well, our viewer has a couple of options. He could file with pro bono attorneys or with reduced rate attorneys. Here in Lake Charles, we have Acadiana Legal Services, which is a nonprofit law firm that provides free or pro bono legal aid in civil matters to economically disadvantaged persons living in our service area. There's the Southwest Louisiana Law Center, which is also a nonprofit law firm. It provides legal assistance to people who do not qualify for free legal services but cannot generally afford to pay the standard rate for representation. Now, in order to file a lawsuit, there are costs that have to be paid up front. However, if our viewer qualifies to file as a pauper, he or she will first need to file a pauper affidavit, and once that affidavit is completed and filed, the court must approve it. So in order to start your court case, you must file, in lieu of the filing fees, that affidavit. Once the judge receives that affidavit and decides whether or not that person qualifies, the judge may or may not approve the affidavit. Those court costs include charges for services, court reporters, copies, and the like. So if the informer pauper pauper's affidavit does not guarantee approval, and if it's denied, then you're going to have to pay those court costs up front. Now, also, please remember to have your third party sign the affidavit, because if that third person does not sign and you submit it, the judge will deny it because it has not been properly completed.
All right.
But those are the options that you do have. Mm-hmm. You can file either as pro bono or with a reduced rate attorney. And if you qualify with the affidavit that was discussed, you will not likely have to pay those court costs up front.
So there are some options available.
There are some options, but the mistake that a lot of people make is they think if they qualified as a pauper, they don't have to pay any court costs. And that may not necessarily be the case. You just don't have to pay up front.
All right. All of this will be on our website if you
Definitely.
have a question. And we want to thank you for coming in, LaKosha. And if you want your legal questions answered, email them to us at news@kplctv.com. We'll send them along to the attorneys at the Southwest Louisiana Law Center. And you'll get your answers every Wednesday right here on 7 News at noon. Remember, civil matters only, please.